Silva Trejos, Executive Director of ALDEC, who will be talking briefly about women in construction. So Silvia, good morning.
Buenos días, hola a todos. Yo voy a hacer una breve intervención en español nada más para, bueno, primero que todo agradecerles a todos los que están conectados por su interés y participación en este Congreso Latinoamericano de Derecho de Construcción. Y bueno, también en el marco del presente Congreso, ALDEC se complace en anunciar el lanzamiento del grupo de trabajo de Women in Construction, que, bueno, este comité tiene por objetivo primordial crear un espacio para identificar, reunir y proyectar a las mujeres profesionales en el sector de construcción e infraestructura, según sus perfiles profesionales, ya que, bueno, tenemos ingenieras, arquitectas, abogadas, peritos, expertos y demás. A través de este grupo queremos crear una red de networking para mujeres, conocer a diferentes colegas con experiencia en construcción y desarrollar eventos entre las asociadas que quieran ser parte de este grupo para enriquecimiento académico. En las próximas semanas estaremos anunciando el lanzamiento de este grupo para aquellas interesadas que quieran ser miembros de este comité. Así que, bueno, les invito a que estén atentos a nuestras redes sociales, que será el medio por donde estaremos publicando la información, y también para que estén atentos a todos los eventos que se van a venir con este grupo de trabajo. Así que solamente quería agradecerles y anunciarles este anuncio, que la verdad estamos muy complacidos desde la Asociación Latinoamericana de Derecho de Construcción. Así que sin más, Paulina y Christa tienen el micrófono y toda la atención.
Gracias, Silvia. So first of all, I want to introduce our moderator, Christa Mueller from Mueller Abogados Mexico. Christa has over 20 years of experience in commercial arbitration, litigation, and administrative litigation. She currently sits as an international arbitrator in the energy, infrastructure, and construction industry under the diverse arbitration rules. She is a member of the Arbitration and ADR Commission of the International Chamber of Commerce, member of the Latin American Arbitration Group of the International Chamber of Commerce, Vice President of the Dispute Settlement Commission in Infrastructure of the International Chamber of Commerce Mexican Chapter, and member of the Executive Board of the Mexican Chapter of the Club Español de Arbitraje, CEA. Christa is visiting professor in the postgraduate program in commercial arbitration organized by the Escuela Libre de Derecho and ICC Mexico. We also have our panelist, Rashda Rana from Rana IDRS from United Kingdom. Rana is a lawyer who directs the firms Rana IDRS in the United Kingdom. She has more than 25 years of expertise in commercial area, construction, and infrastructure. She has worked as counsel and arbitrator in multiple international jurisdictions, such as London, Australia, Hong Kong, Singapore, Malaysia, and China. Also, she was president of Arbitral Women, and currently she is co-president of the Dispute Resolution Subcommittee of the IBA International Construction Projects Committee. We also have Diana Droulers from Droulers and Asociados from Venezuela. Diana is an arbitrator and mediator with vast expertise in the creation and management of arbitral institutions worldwide. Diana has served as an arbitrator in the ICC, ad hoc, and Caracas Chamber cases, and as a mediator international. She is a member of the ICC International Court of Arbitration, and she has advised parties in revising cases and devising case strategies. She has overseen more than 600 arbitrations and mediation cases and holds leadership positions on a number of advisory boards and arbitral interest groups. The Reporte, the Institute for Transnational Arbitration, Arbitral's Women Group, the Asociación Venezolana de Arbitraje, and the Spanish Arbitration Group Club. She's on the arbitrator panel list of various institutions, and Diana brings her cross-cultural insights to bear as dispute resolution data advisor and helps ensure the DRD is recognizing and meeting the needs of arbitral institutions and data subscribers globally. She is ranked by Who's Who of the Global Arbitration Review. And last but not least, we have Jacquelin Gutiérrez from Mexico. Jacquelin is the legal director of Diamond Generating Corporation Mexico, the branch of the generation of electrical energy of Mitsubishi Corporation in Mexico. Jacquelin is a lawyer based in Mexico with extensive experience in legal aspects related with the development infrastructure and public-private partnerships, including their construction, public contracting, and granting of concessions of goods and public services. Her experience includes also regulatory environmental issues, urban development, railroad, among others. So thanks to our panelists today. Now I give the word to Christa, who is the moderator.
Thank you very much, Paulina, for the introduction of our magnificent speakers we have today. Good morning and good afternoon to all, and welcome to panel 3 of this Congress. As you already heard from Paulina, we have a panel of exceptional women with an impressive trajectory in construction arbitration. Let me just add maybe a little bit more of what has already been said about these 3 wonderful women. Rashda is not only an outstanding member of the arbitration community, but she's very committed to the advancement of gender equality. We heard she was president of Arbitral Women from 2014 to 2017. And Diana is close on her side. She's also very active in this regard. She's very close to the pledge. She's a widely known arbitrator and a vital figure in our community, as well as a great mentor. And Jacquelin is a brilliant lawyer working at one of the cutting edge industries in the clean energy sector, who brings great insight regarding the experience and perspective of in-house lawyers. Now, during our panel, each speaker will address a key issue from the 2019 ICC report on construction industry arbitration for approximately 7 minutes, followed by the intervention of any of the other speakers for no more than 3 minutes, please. So before I give the floor to our speakers, I think it's important to just maybe point out that the report is primarily focused on helping young arbitrators or arbitrators that don't have so much experience in construction arbitration. Nevertheless, I do believe it is a very handy set or toolkit that helps even the most experienced arbitrators and parties, because it compounds in a, I think it's 26-page long report, these techniques that help us in designing efficient proceedings in construction arbitrations. And these recommendations, they range from pre-arbitral issues such as the selection of arbitrators all the way to production of documents, evidence and submissions, hearings, and even, if possible, settling of the case. So despite the broad spectrum of the report, and for the purpose of this panel, we're going to focus on crucial issues identified by each of the speakers throughout their practice. So that being said, let me start with you, Rashda. We all know that construction arbitrations tends to be more complex, both factually and technically. And for some reason, construction arbitrations, they require much more documents than I think any other kind of disputes. So what do you think is the significance or the role of document control in construction arbitration?
Thank you, Christa, and thank you very much for inviting me to be a part of the panel. And also thank you very much to the organizers for indulging me in allowing the panel to go ahead in English. I feel very inadequate that I ought to learn Spanish. I did tell Christa I speak Italian, but it's not fantastic either. So I'll just stick with my other language, English, for now. I think it's interesting that in construction, as you say, somehow we managed to create so much paper. I want to just give you one anecdote before I move on to the importance of the report in relation to this particular aspect. Some years ago, I dealt with an historical building where the original contract from something like 1880 was 10 pages long. And it is a former court building, and I had to do some work on the refurbishment. Somebody sent me the contract, and I can tell you all of the issues that we deal with in our 400, 500, 1,500 page contracts was in this 10-page contract. And of course, they built a beautiful building which is still standing. So there is an issue that arises in relation to the number of pieces of paper that we can generate. And nobody will be surprised that in terms of when an issue gets to a dispute, and once it actually gets before a tribunal, whether it's an arbitrator or court, it seems to have built a mountain of paper for the proof of sometimes a very simple issue. And I think IT and particularly project web portals have not necessarily diminished the idea of how much paper is needed to support a claim. So I think this is very apposite, and it comes at a very important part in terms of dispute resolution, partly because of the continuing costs that we all face with dispute resolution. And not just as a counsel acting for a party, but as arbitrator, I'm always conscious of how much money is being spent every minute of the day in terms of documents. So I just want to run through a couple of particular issues that this particular segment of the report seeks to deal with. And in the large umbrella, it is really document control. So how do we ensure that we are not faced with lorry loads of paper to deal with the disputes in issue? So document control becomes really the role of the tribunal, because if the tribunal does not take a handle on it and act robustly in controlling it, then it'll just go out of control, and we'll end up with unnecessary, irrelevant paper. So one of the elements that they sort of run together is the need to avoid duplication. We will have all seen that every witness statement has the paper duplicated over and over again. Instead of creating perhaps a bundle of evidence so that people just refer to the particular document, and we all know there's always a sort of letter that is the crucial letter, and it's often duplicated 10 times in 10 different bundles and in 10 different witness statements. So that avoiding duplication becomes a very important aspect. And nowadays with electronic documentation, it is very easy to ensure that you have the one document. Of course, if there is a document, the same document that has annotations in it, you may need to ensure that the annotated version also is included in the bundle. And this leads on to ensuring, and this again the tribunal's role, that the compilation of the working files is also controlled and only focuses in relation to the issues in the dispute. And I think eventually, parties end up with what they call the core bundle, which really is the key documents that each party will have to refer to, and each party will go back and forth about what those documents mean. The next one is one that I mentioned earlier, which is whether using project databases, existing portals that the parties may have used during the course of the project, the delivery of the project, is a worthwhile thing. I think there are some difficulties that are still presented because of confidentiality, because of often relevance, and of course third-party rights, because often all parties are part of this portal. So unless you can actually demarcate the use of it between the tribunal and the relevant parties, it can become a little bit of a minefield. But they are useful if handled properly, but they can be fraught with difficulty. The next item that really is a headache and a nightmare for most parties is disclosure. And I think the reason that this is a runaway train, uncontrollable train, is because people, parties, including lawyers, still do not focus on what is a relevant document. So in a very short, pithy way of looking at it, the principle that ought to apply is the statement made in this particular document going to affect the assessment of the issue in dispute? So will it help me as the tribunal to work out what is right or not right, or what is what affects the issue or not? If it doesn't affect the issue, you know what, it's not relevant. Just because there was an email sent does not make it relevant. But if it says something that goes to the issue, then of course it becomes relevant. So I think that particular discipline that lawyers and parties can bring to bear will immediately become a cost-effective tool to help minimize the amount of documents that go out. So for disclosure, it is the same exercise, and schedules that help with analyzing which documents I want, what issue does it go to, does it prove X or Y, letting the other party have a response, and then ultimately for the tribunal to decide. They're very useful. I use them all the time to help focus the minds of the parties in terms of what is needed and what is not needed. And I think, again, to make the parties consider each document that they want to put up or they want the other party to disclose is a very important aspect of ensuring that the documents that come to the tribunal are only the relevant documents. Of course, people forget that arbitrators can actually ask for documents if they think they are relevant and they're not before the tribunal. I don't think that poses any notion that you've already made up your mind. You do need to be clear that you're asking for it because you think it affects the issues and you're remaining impartial. And the ICC rules provide for that, and the report reiterates that you're not doing anything untoward in asking for it. Now, a further step that tribunal can take is to include a cutoff date in terms of when production will have to stop. So instead of giving them years and years, I was in an arbitration that disclosure itself took about 18 months. I couldn't believe it. I was counsel, but, you know, and I was asking for some of the documents, so perhaps it was a bit of my fault. But if a cutoff is provided, again, it helps people focus their minds. You know, when there's a deadline, people will do everything to get to the deadline rather than carry it on forever. So a deadline for disclosure or production is always a good idea. And then lastly, I think having an agreed pre-hearing reading list for the tribunal also helps focus the minds of the parties. So this could be firstly a reading list in relation to sometimes witness statements, a reading list in relation to key or core documents, and then sometimes, of course, a reading list in relation to law. You might want them to look up some cases or give them some cases that help them either in document control or indeed in the issues in dispute. So the section 16 of the report effectively deals with all of those elements that I've tried to get across as succinctly as I can. And they're the elements that everybody really needs to focus on in order to ensure that what we're looking at in an arbitration are really the issues being determined according to the best evidence possible. Thank you, Christa.
Thank you so much, Rashda, and thank you for keeping your intervention under or exactly at 7 minutes. I think relevance is key, but I was counsel for almost 15 years, and I know that sometimes we're acting more under the lemma of better safe than sorry, and we'd rather over-present our case than under-present it. But I guess that's just something we have to work on hard. And I think that the arbitral tribunal's function can also help a lot in helping the parties really just get to the relevant facts. So Diana, would you like to comment briefly on this topic?
Yes, you know, when we normally talk about documents, we normally talk about production of documents. Your whole point is you need to get organized to be able to find what are really the important facts. So all these tips that come in our document and that Rashda has so well described, I think there's one part after the closure when you say, okay, enough, we've received enough documents, this is the cutoff time, we're not going to have any more documents. And then you as an arbitrator start to look at all the papers, and all of a sudden you find a blank. Maybe there's a sequence where there's, you know, documents from 1 to 10, and then you find that there should have been one called 7.5 because something important was in that document. And so you have to refer to the parties and say, okay, I need this additional document, or I have this specific blank and I need you to fill that in. And I think that's something extremely important, and that's one of the reasons the tribunal has this faculty in the rules to be able to ask for documents. As was said, you have to be very careful when requiring this document from the parties, because you must never let them think or let the other party think that you're asking for this document in order to help this party prove something. You actually have to explain very well why I need to fill in this blank, which is the blank I want to fill in. And the fact is, what you need from the parties is this story, and you want a complete the complete story with every single chapter and every single page. So that's the only comment I would have.
Thank you, Diana. Jacquelin? Would you like
Yeah, well, I think an issue that's important having to do with document control has to do with something we're going to talk about later on, which is quantification of claims. And a proposal that is related to what the report says is the establishment of a standard of substantiation of claims, because like you said, Christa, you know, as counsel, you want to be better safe than sorry, and you can provide endless substantiation of claims. So I think establishing rules for that, a standard of support of claims is important early on. So, but we'll talk more about that later on.
Thank you, Jacquelin. So definitely knowing what, when, and how to present your case is crucial, especially in avoiding overwhelming the arbitral tribunal, because it gets to a point tiring when you've gone through the same document 5, 6, 8 times, and when you're reviewing the case and half of your office is full with boxes, and then it turns out that what the core bundle would have been almost sufficient, it tends to be kind of frustrating. So now that I'm more as an arbitrator, I really understand that, and I really think counsel should try to be a little bit more conscious on that matter. So anyway, moving forward, my next question is for Diana. And Diana, expert opinions are fundamental in shedding light on specific technical issues. And as an arbitrator, I'm sure that there have been times when, after hearing the expert opinion, you're left with more doubts or more confused. I know it's happened at least to me. So how do you believe we can optimize the use of experts?
Well, I think, first of all, thank you for having us on this wonderful panel and with my colleagues. And the whole point of the document that the ICC, well, normally the whole point of the documents that the ICC elaborates on for the parties are also extremely useful for the arbitrators. So we always say the arbitrators have to somehow follow the parties' guidelines in the sense that they are the owners of the process, supposedly. And so the tribunal, which is made up of probably party-appointed arbitrators, and then they appoint the president of the tribunal, is an expert on the law. But many technical issues or accounting issues, or even some legal issues, when it's a very particular industry, can be lacking. They can be lacking the knowledge of that particular thing. So what do we need? We need a reliable source of information on a specific issue. And where do we go? We go to an expert. And what makes an expert? Not only that he studied that, but the experience that he has in that particular area. And so experts sometimes are hard to come by if it's a very particular area of construction. And that in itself is a challenge, because many times one of the parties already has one of those experts as a consultant in order to make their claims. So one of your challenges is you have to review very well if the experts that are being nominated are actually have the experience for you to be able to source the knowledge from them. So that's very important. the experts obviously could be party appointed, or they could be appointed by the tribunal, or there can be mixed appointments, which I don't, in my experience, is not the best case scenario. But some parties, when they don't have counsel, doesn't have the adequate experience, they think that nominating our experts can be just as nominating arbitrators. So I'll name mine, you name yours, and they will name a third expert. And that usually doesn't work that well. Obviously, what you need to have clear from the beginning, from the parties, is what kind of expert do you need in order to help prove the evidence that the party is presenting. So the whole point of the expert is to have the useful information to help the tribunal in the deliberations and find the decision. So what is your biggest challenge with the experts? You need to organize the job. And in order to organize the job, you need to be very practical. And the first thing that I've encountered problems with is you need to sort out who is going to pay the experts. If it's a tribunal appointed expert, if you ask an institution to appoint that expert for you, if the parties appoint the expert, the first thing you have to put in your terms of reference for the experts is who is going to pay that job, because that could always, and how much is that job going to cost? Approximately. Is it by hour? Is it a whole, package? Because although that doesn't seem important in the sense of what you need is the story the expert is going to tell you, you need to know how you're going to pay for it, because if you leave that till the end, it can really be a huge problem for the cost management and for the time management. And so obviously you have to have the conversation of experts since the beginning of the arbitration, and you have to, leave reference of that in the procedural timetable. You need to have it in the terms of reference, and you need to give the experts terms of reference. You need to check the scope of the evidence that's going to be proved. You need to see if there's going to be documents that are going to be expertized, or if it's going to be an on-the-field expertise, and what those costs will bring to the arbitration also. Then you need to have the terms of reference for the expertise and the declaration of independence of the experts. When the experts are party appointed, it needs to be very, very clear what is it exactly that the party is trying to prove with this expert. That's really, really important. And then you come to the problem of the reports. You need to know if you're going to have, sometimes parties want to send each one a report from their expert, and then the tribunal is faced with two different options, which is almost like the claim and respondent. So no, that's not really what you want. For practical reasons, what you need is the experts to get together and be able to file a joint report where they won't be with a checklist that is not going to be, oh, this is what we all agree on, and it's a long, long report on what they all agree on. No, it has to be a report, a good written submission that really differentiates what are the differences that the experts have, the different opinions that the experts have on one issue. So you will be able to talk about it. What else? The prior approval of the parties, I went through that. We have to be very careful with what comes with the handling of the expertise and the timing of the expertise, because in my experience, I had one very unfortunate incident in an arbitration. It was a very big arbitration. It was a complex arbitration, and the parties decided that they were going to have an expertise, which of course we definitely needed. and each one named their expert, and that expert named the impartial expert, because they named experts that were the engineers that were on the job. When the construction was going on, the experts from the parties were the guys who were on the job. So they were, of course, they were not together, and they were each defending their point of view. And since they had been, since the beginning of the job, doing that, they were obviously not going to say, well, this part which I did is wrong, or this part that I supervised is wrong. So it was left to one expert, when the parties were paying for the three, it was left to one expert to really be the one who's, in our opinion, his opinion was the most important. And this guy was not, he wasn't a forceful person. He couldn't stand up to the other two. And that made us, we asked for, more time in the court in order to be able to close the procedure and deliver deliver the award. And it was very, very difficult. With the fact was, the tribunal later had to go ahead and name another expert, which was a sole expert, in order to do an expertise on the document that they had sent us. So it was expensive. It was really not efficient at all in time, and it was just a huge complication. So you have to be careful that when it's not the law, the lawyer needs the expert, but the expert has to have a very clear-cut job to fill. I'll leave it at that.
Thank you, Diana. Jacquelin, would you like to add something on this topic?
Well, I guess the only comment that comes to mind is when an expert, non-plus ultra expert, is part of the tribunal in a very specific technology or process or science, and the other members of the tribunal have so much deference towards that expert that it really places kind of undue, it's a little bit of a deferral of responsibility also from the other party. So there has to be a mechanism by everybody involved to be wary of undue influence by the expert in the tribunal. But that's pretty much it.
Thank you, Jacquelin. That's definitely a very important issue to look after. Rashda, any comments?
Yes, I just wanted to add to something. In fact, Jacquelin was saying in relation to tribunal appointed experts. I was in a matter where the tribunal appointed an expert, wouldn't let us appoint our own experts. And each party cross-examined all the evidence out of the expert, so nothing was left. So in fact, that evidence became useless.
Wow.
I know, and it cost a lot of money for this person to give the evidence. But I just wanted to pick up on, the perennial problem of the expert actually having the expertise that again goes to really assisting the tribunal on in determining the issues. And there are a couple of cases in England, and I just wanted to read to you what the judge said about these two particular experts. In the first case, the judge said, I won't name him, Mr. A is not an expert of suitable caliber. He had little or no understanding of the duties of an expert. He had received no training and attended no courses. He has no academic qualifications. His work has never been peer reviewed. And you can imagine what the judge then went on to say about this expert. In another one, the court said, there is no room for complacency, and the case stands as a stark reminder of the need for those instructing expert witnesses to satisfy themselves as to the witness's expertise and to engage, difficult though it sometimes may be, an expert of suitable caliber. So just the fact that a person says, I'm a programming expert, I'm an expert in quantum or whatever, if you don't do your homework, your sort of due diligence to make sure that this person actually has specialized knowledge, this person can actually contribute knowledge in terms of assisting the tribunal, then that person is really not an expert. And certainly when I teach, I do try and explain to students in law, especially when you're looking at expert evidence, that that person is the only one who's allowed to give an opinion in a hearing, whether it's court or whether it's arbitration or some other form of adjudication. So counsel aren't allowed to give an opinion. You can't say, I think, you should do this. This is what I reckon the position is. Witnesses of fact can't give an opinion. They're there to just give evidence of what they saw, heard, felt, smelled, said. And the only person in that position in a hearing who can give opinion is an expert. So you better get it right if it's going to be of any use. Thank you, Christa.
Thank you so much. So definitely we can see that appointing an expert is not an easy task, and counsel definitely has to do their homework, as Rashda just mentioned, and really knowing that even if they have these great qualifications, they also should have the sensibility of knowing how to present this information in a manner that the arbitral tribunal, which is not an expert on the matter, will understand their findings. So anyway, let's take it to our last question, which is for Jackie. And it seems we've left one of the trickiest questions, I would say, for last, because compilation and quantification of claims, I think it's always one of those very difficult issues in construction arbitrations, especially because sometimes we see that at the beginning or on the very offset of the arbitration, the claimant, they present their case, but there's really not a clear definition as to where these amounts are coming from and what they're based on. So Jacquelin, what would you have to say on this regard?
Yeah, I mean, in my experience, quantification of claims has been one of the absolute obscure sciences that can lead to everybody drowning in documents or not understanding anything at all. As a matter of fact, I'm sure this has been your experience as well. A lot of disputes do not necessarily hinge on the allocation of liability. Like, the parties know who's responsible, but they don't know for what. So the dispute really lies on the size or the dimension of the financial consequences of the liability or the event. And another problem arises in claims having to do with early termination of contracts for very large infrastructure projects or construction projects, but in my case has been infrastructure projects where even when the termination of the contract has been decided or decreed, there's a lot of ongoing work that has to keep going in order to secure the place, to make sure that it doesn't fall apart if the facility is partially constructed. So while I do agree with the report when it says that that it is recommendable or advisable that the parties from the get-go try to establish a quantification of claims, I think that's not always possible in construction. I think rather than saying that that for the tribunal to invite the parties to establish the quantification from the get-go, I think it's important to invite them to set a clear methodology for the quantification of the claim and a standard of substantiation, which has everything to do with document control and also the designation of experts. So it's a little bit difficult because it's a preliminary agreement that the parties have to come to say how what is expected of each of the claims in order to, to provide support and analysis, which, could leave the parties thinking that that already includes in itself a determination of how far they can get with claims. But with ongoing expenses, like non-recoverable expenses, where even specific expertise has to be mobilized into the area. And I think a clear example of this is the airport in Mexico City that was canceled. People had to be mobilized in order to secure structures. I mean, that activity that wouldn't otherwise have taken place, that was not originally taken into account in the budget, but had to be done in order for the structures not to fall apart and either create contamination or be completely unsafe for people walking around. So that is a very specific problem that we've been faced with in the cases that I've been involved with. So I mean, it hasn't been easy, and it almost involves an entirely different dispute in order to agree on the standard of substantiation and support. So I think that is but like the participation of the tribunal to make sure that the parties do come to an agreement in that, I think saves a lot of headaches in when the process evolves. So that's it.
So thank you so much, Jacquelin. So we don't have any questions right now, and we have 10 minutes. So if I'm going to abuse the use of the microphone, and I'm going to start with you, Jacquelin, just to see, would you have any suggestions or something you would like to see, or you think that arbitral tribunals could improve on this matter that you just talked about?
I think that, from the beginning of the process, when you identify that in the statement of defense or the statement filed, there is not enough support to the claim, or there is too much support to the claim, or the claim is not clear, or the members of the tribunal detect that there are ongoing activities that will increase the size of the claims, that you set apart some specific interim process to determine methodology and standards and rules for substantiation of claims. Because sometimes, and this happened to me in one case, sometimes you don't even know at the time of filing, requesting for arbitration, you don't even know how you're going to substantiate that a claim, because you have to develop an entire action plan for remediation or for containment. But you do know that you have to get it in from the beginning, because otherwise, I mean, that's going to be a significant cost. So I think the faster that the tribunal detects it, and the faster they intervene to make sure that, because one of the parties does benefit from the ambiguity of the ongoing claims, or the claims that have ongoing measures. They're really going to have to mediate with the other party to convince them that they have to agree to set rules from that moment, and they're going to have to accept information that is going to be generated in the future. So, I mean, I think they have to be very, very assertive the members of the tribunal in that case.
And this is where the having an experienced arbitral tribunal is always key in and obviously selecting those arbitrators. So Diana, I wanted to get back to you with the whole expert reports or opinions. Do you, when you're sitting in an arbitral tribunal, do you require the parties to agree on the statement of issues and facts that are going to be the matter of the expert opinion, or do you just let the parties define what they think the scope of the expert opinion should be?
Well, I go more for a guideline, not so much require the parties, but suggest to the parties, because sometimes they have ideas that have not come up in my head. So, I mean, they are the ones who know their case and how they have to present it. So more than requiring, I would say guidelines and letting them understand with a soft hand, one would say, what is it? I mean, you want something useful, because in the end, it's not that it's going to be useful for me. So that you're paying for arbitrators to give you a decision, which is a good decision. So it's sort of a chain. If you don't give me the right information in the way I can read it, how am I to give you a better solution? And I do have one little comment for, the claims, the amounts. And that would be that since our departure for this panel was a document emanated from ICC, I think it's important, the quantification of claims, one must forget, that's always very important for how much is it going to cost, how much is the institution going to cost, and how much are the arbitrators going to be paid for this case. So in fact, financial planning for the case is important. It is important for the financial planning of the case to know how much the claim is at, what is the exact amount of the claim, because that can be changing throughout, throughout the procedure. But in the beginning, you kind of need to know how much is at stake, so that all the financial planning of the case can go ahead with the institutional, how do you say, the attachment to the institution.
Absolutely, Diana. Thank you so much for that. Rashda, last but not least now, you made specific emphasis on the relevance of documents, and I think that echoed really with me. So I wanted to ask you, do you sometimes use this technique where you ask the parties to state what they intend to prove with each of the documents? Because there's a lot of different approaches. Some arbitral tribunals, they just say, well, we don't like that formality, and some do. So what is your standpoint there?
Yeah, thank you, Christa. I think it comes down to the range and ferocity with which the documents are being sought by each party. Sometimes, the list is very small. Sometimes it's very extensive, and it's hard to get your head around why all these documents are needed. I think more so what the list or the schedule does do is to force the parties to really consider whether they need it, and therefore to be able to explain why they need it. And just to say, I want to have a look at it, is sort of not enough. And I think therefore, depending on, the range of the issues, the complexity of the issues, I will sometimes require it. And I am actually a fan of a statement of issues, because I was in a case where towards the end of the hearing, I was sitting on my own. I wrote out what I thought were the statement of issues that arose from everything I'd heard and seen. And I sent it to the parties, and I said, would they have a look and would they agree it? They came out with completely different ones, each of them. So I said, well, I actually want you to agree the issues, because I want to be able to then deal with, understand what it is you're asking me to determine, because I thought it was ABC, you're telling me it's XYZ. And then they actually, in between them, agreed it and said, no, we want you to determine 1, 2, 3, 4, and so on. And then again, that made them think about what they're actually asking me to do. And if I may just add a little bit to what Jacquelin was saying, I absolutely agree with her with the problems that you get with claims, particularly quantification. And I had in mind, actually, recently I was helping a party in which they had lost millions of pounds, and because there was a loss of millions of pounds, they thought that was their claim. But when I got them to go away and give me supporting documentation to explain how this amount related to the loss, which actually related to the the contractual entitlement, that millions started coming down very quickly because they just couldn't substantiate the amounts. And if you think about it, how many times have we all dealt with the issue of whether loss of profit is claimable? So there are lots of amounts that you can think of in the total of what might be lost. And, again, another one off the top of my head, when you think of delay loss, delay costs, they are, I think, one of the hardest to even conceptualize, even before you start putting numbers against it. And I think Jacquelin was absolutely right that the difficulties in terms of the amount that you claim are much harder than people actually imagine, and especially the lay client imagines, because they have a figure in mind and it must be that's what I'll claim. And then, as we know, it just snowballs into either the documentation in the hope to prove it, or some reality, a sort of reality check that brings the amount down to a reasonable, claimable, provable level.
Thank you so much for that. So we have 3 minutes left. I don't know if each one of you would like to just have a 1-minute closing statement. Diana, I see you're eager.
I have a small comment on what Rashda just said. We had a whole arbitration where the arbitration was based on the interpretation of a clause in a contract, just to know if that clause did or did not include the loss of profit. And the parties had agreed on the formula how to calculate in case there was a loss of profit. They already had the formula calculated, but the only thing they wanted from us, the tribunal, was, does this clause include or not the loss of profit? And it was quite an interesting case. It was a different case. And yes, my closing comment, thank you so much, Christa, and thank you so much the other panelists and ALDEC for having me. And I think it's been a very interesting discussion. Thanks.
Thank you, Diana. Jacquelin?
Well, I think what I've heard from all participants here is that I think the importance of the intervention of the tribunal in getting the parties to make small agreements along the way that will shape the process and the success of the process, be it on what is the claim, how it will be supported, how it will be documented. I think it just makes it the more clear that having a good tribunal is very, very important. That's it. And thank you, Christa. Thank you to my fellow panelists for allowing me to be here with you.
Thank you, Jacquelin. Rashda?
Very quickly, again, thank you, panelists. It's been a fantastic discussion, and so honored to be a part of it. I think what really does come out when we have discussions, especially about construction, is again the involvement of the tribunal to ensure that the whole process is fair. Yes, that goes without saying, but cost effective, and not to sit as a Buddha and have the wave of evidence being thrown over you, but actually be an active participant. It's as much as your arbitration as it is theirs, and you are there to help guide them through it in a cost-effective and timely manner.
Absolutely. Well, thank you all three of you for sharing your time, for taking the time to prepare for this panel. It was wonderful sharing the panel with you today. And thank you again for ALDEC for this platform. And we hope to see all of you in tomorrow's sessions. And thank you again for joining us.
Thank you.
Thank you. Thank you, everyone. Take care. See you soon.
Bye-bye.
Yes.
Hope until